When Neha had asked me to come here and speak, she kind of told me to put together a package of cases that either I'm doing or I'm aware of in this past 1 year, which will highlight any changes, if any, in the judicial system vis-a-vis those cases, the Constitution of India, the rule of law. One of the least scrutinized bodies in this country is the judiciary. I've actually just come from a meeting at Hindi Bhavan where they were holding a protest against the arrest of Mr. Sai Baba, a lecturer of the Delhi University, under the UAPA Act. Now, here is a man who's 90% disabled. At a time when he first came to me 2 years ago for advice, he had to be carried into my office because he was wheelchair bound and he couldn't walk into my office. He had received a notice from a police station in Gadchiroli asking him to participate in investigations under the UAPA Act in Nagpur, knowing fully well that he couldn't travel to Nagpur. We responded by saying that Section 160 of the Code of Criminal Procedure had been amended, and any investigation or interrogation of a person who is disabled has to take place in his residence. The Gadchiroli police obviously had not got to know of the amendment, and so it grappled with it for 6 months and then came to Delhi and interrogated him in Delhi. Thereafter, last year around this time, he was arrested and is now in the Anda cell in Nagpur. I don't understand how people like him, whatever be his thoughts, whatever be his utterances, whatever be his political beliefs, should constitute as a threat to the Indian nation. But they are. And it's not just Sai Baba. Sai Baba's case is an extreme case because under the law he should be granted bail. He's a disabled man. He cannot move. Even for very basic human activities he requires assistance. But the state watches while he suffers in a draconian jail in central India for crimes that are never really proved ever on paper. But Sai Baba represents just one of those many, many people for whom the law is not equal. On Monday, we filed an appeal on behalf of 43 victims of the Hashimpura massacre against the order of acquittal, which had been passed by the trial court in Delhi, where 16 men accused of having murdered 43 young Muslim men from Hashimpura Mohalla were acquitted on grounds of lack of proof. It's interesting, and I've said this at different forums, I'm going to say it here again. It's interesting how standards of proof changes for the judiciary. So when the victims are Muslim, or the victims are vulnerable, or the victims come from underprivileged sections of Indian society, you look for proof beyond reasonable doubt. Now, I am a criminal lawyer. I know that you must look for proof beyond reasonable doubt in every case. But where the accused is rich and powerful, or where the accused wields considerable power, there is, they really don't care. And so even if there's proof, they say, this is not good enough. So an Amit Shah will get discharged, a Narendra Modi will never get charged. All the officers involved in the extrajudicial killings of Ishrat Jahan, Sohrabuddin, Prajapati, etc., are all let off on the ground that there is no proof beyond reasonable doubt. However, when Muslims or others are asked to face trial under the UAPA Act, courts actually apologize for the prosecution. They say there's no need for proof beyond reasonable doubt. You are a member of an unlawful activity. God alone knows whether there is any evidence to suggest that you're a member of an unlawful activity. So under Section 20 of the UAPA Act, you are imprisoned for life. So it's interesting how standards of proof shift in a judicial system. For those people who require the benefit of the law, the courts insist on proof beyond reasonable doubt, and acquit or discharge the perpetrators of the crime. For those who are prosecuted, and clearly the courts must insist on proof beyond reasonable doubt, there the courts say, it's okay, it doesn't matter, there need not be proof beyond reasonable doubt, we are convicting you. I represent 5 men who are accused of having planted bombs in Delhi in 2005 during Diwali. Needless to say, they're all Muslim and they're all Kashmiris. Needless to say, there is not an iota of evidence against any one of them, particularly against the one man that I personally represent, Mohammad Rafiq Shah. The allegation against him was that he planted a bomb in a bus in Kalkaji. However, the special cell which prosecutes him itself concedes that there is some evidence to suggest that he was in a class in Kashmir, in a university in Srinagar, on the day and around the time when the bomb exploded in Delhi. Despite that, for the last 10 years, he remains in custody, has not seen the outside world for a single day. Where is proof beyond reasonable doubt here? It doesn't exist. It doesn't exist. And yet, courts are complicit in their silence when they refuse to grant them bail, when they refuse to fast-track these cases, when they refuse to acquit them. The point I'm making here is that this problem has existed for a while. It's not like it has gone worse or gotten worse during the last 1 year. But what has happened during the last 1 year is what we've seen is how easy it is for certain people to get the benefit of the law. So while Amit Shah is discharged in super fast time, while all the police officers from Banjara onwards are all discharged or acquitted, a memo of charge under very, very frivolous charges is framed against Satish Verma, a very brave officer from Gujarat, who was in fact instrumental in filing the charge sheet in the Ishrat Jahan case. What is the memo of charge against him? You were on deputation between this period and this period. You took one extra casual leave. You were on deputation from this time to this time. You were supposed to join at 11 p.m. You joined at 2 p.m. As a consequence of these absolutely frivolous charges, he's denied promotion and sent to Mizoram to look after some random organization there. Not that he has any difficulty going to Mizoram, but this is the manner in which the state treats those officers who had used their skill, their integrity and honesty to prosecute people who were guilty of mass crimes. While I'm talking about what has happened in the last 1 year, I cannot help but again look at the role of the judiciary when it comes to defending civil liberties. Now, there's been much celebration about the judgment passed by the Kerala High Court yesterday, where the Kerala High Court said that just because you're a Maoist, you are not a criminal. Why should there be any celebration? Clearly, there should be a judicial pronouncement in every case. Why does it take so long? And why is there just one singular pronouncement? Because I will tell you with all the experience in my command that judgment will be overturned by the Supreme Court. It's just a matter of time. Now, the judiciary, which by and large pretends it's above all these formulations, is guilty very often of abdicating its responsibility, both under the Constitution of India and also while defending human rights and civil liberties. How else can you explain a situation where 20 people are shot dead in Andhra Pradesh on the ground that they are smugglers, and there is no judicial monitoring of that incident? The victims have moved the National Human Rights Commission. The Andhra Pradesh High Court has been moved because the victim families have gone. But so moto, neither the Supreme Court has been interested in that case, nor any other High Court. How is it that 5 men who were transferred from one jail in Hyderabad and were being taken in a police vehicle handcuffed were shot dead on the same day that the Andhra incident took place, and there is not a murmur against those police officers who committed cold-blooded murder. So this is a country where we celebrate police excesses. This is a country where we allow custodial killings and custodial torture to go unpunished. This is a country where the judiciary is very, very selective when it comes to granting relief. So a Salman Khan or the Satyam founders will be given bail as soon as they are convicted. But a Sai Baba, who is in custody, who admittedly cannot be called a danger to the state, he's 90% disabled, will never be granted bail. How is it that the judiciary will not intervene when it comes to those rape victims from Muzaffarnagar, but we'll make a big song and dance about the Uber cab incident and the Nirbhaya incident, not that they were not gruesome crimes? Where is equality before law? It doesn't exist. In the Muzaffarnagar rape cases, the FIRs were registered after consistent interventions by human rights groups. Many of those women are living under threat because the perpetrators of those crimes are their neighbors and have threatened to eliminate them. Where is the protection of the state? It doesn't exist. However, we make a big deal and fast-track cases which catch our attention, which catches the attention of the media, which also is highly compromised. And we give the impression that by doing these gimmicks, everything is well with the Indian judicial system. Far from it. 147 workers were arrested back in 2012 in what is called the Maruti case. In February of 2015, 2 of them were granted bail by the Supreme Court after a marathon struggle in a case where there is zero evidence. Today, more than 100 of them have been released on bail. Why is it that the High Court of Punjab and Haryana, while dismissing their bail application, said that these men created such an atmosphere of terror in the country that foreign investment was not coming into India? These are, some of them are apprentices, some of them are contract laborers, and on their shoulders rests the responsibility of bringing foreign investment into India. And because they are named in the FIR or not named in the FIR, but are part of the 147 group, the High Court, no less than the High Court of Punjab and Haryana, in an order which was challenged in the Supreme Court, said that it was the atmosphere created by them that resulted in giving India a bad name outside and which prevented foreign direct investment in India. What do you do when you have judges of this caliber in this country? What do you do when they're openly complicit? What do you do when there are different standards of proof for the poor and the vulnerable and for the rich and the powerful? What do you do when the system is so openly partisan? Really nothing except fight and live and fight another day. As we speak, there's a very interesting constitutional fight which is going on between the Delhi government and, I would say, the centre, through the Lieutenant Governor. When I came here, as it is my job, I always carry with me the Constitution of India, Aadat se majboor hoon. But I just wanted to flag a particular article of the Constitution of India, which has been oft quoted in the last couple of weeks, 239AA of the Constitution of India, which makes it absolutely clear that the government of the NCT of Delhi is run by the Chief Minister and his Council of Ministers. And they will aid and advise the Lieutenant Governor. And in case of conflict between them and the Lieutenant Governor, a reference will be sent to the President. What business then does the Lieutenant Governor have to say that from the Pune to the Chief Secretary, I will make all the appointments? Now clearly, this is sponsored. And clearly, an attempt is being made to muzzle the popular voice. You can have a lot of problems with the Aam Aadmi Party. They've often of late shot and made crazy statements. But they are a party with 67 seats. They did win the popular vote. How does a lieutenant governor get the power to do what he's doing now? And how does he get away with it? And where is the judicial intervention, suo motu, that they like to say all the time? We suo motu intervened. Where is that judicial intervention? They will do that in a BCCI matter where some stupid cricket team from Chennai is involved. And they will spend hours and hours debating whether that cricket team should be allowed to be part of the IPL or not. But they will not intervene in a constitutional crisis that is clearly playing out in the national capital in Delhi. Now, all of this is evidence of what will come in the future. Our voices are being muzzled. There is fear, there's palpable fear. The fact that people are being picked up under the UAPA Act and such like acts, Makoka and such like acts, and are in custody in jail for years together, and there is nobody interested in seeing whether they are going to be released or not, is a very worrying feature. On top of that, you have what is known as the Gujarat Anti-Terrorism Act, where now what they used to do illegally and very brazenly earlier has become legalized. Everybody's phone conversations can be tapped. Everybody's phone calls can be intercepted. It is now legalized. So before this, the special cell was doing it anyway, except that it was illegal. They couldn't openly say they were doing it. Today you have a law which says, we will do it. And there is nothing at all that the judiciary, which is supposed to protect the Constitution and the laws, is doing about it. I'll end by making another reference to another act which is deeply disturbed me, actually two of them. One is the amendment to the Juvenile Justice Care and Protection Act of 2000. There's a fresh act under 2014 where they're criminalizing young children of the ages of 16 for heinous crimes. And there is the Child Labor Prohibition and Regulation Amendment Act of 2012 where, and this is very interesting, and I'd like to read that out to you. No child shall be employed or permitted to work in any occupation or process, provided that nothing in this section shall apply where the child helps his family after his school hours or helps his family in fields, home-based work, forest gathering, or attends technical institutions during vacations for the purpose of learning, but does not include any help or attending technical institutions where there is subordinate relationship of labor or work which are outsourced and carried out in home. So a child today is allowed to work and to be employed. That's a child protesting, actually. Allowed to be employed after school hours. Now, which child are they looking at? Which section of society is this act addressing? Two really disturbing acts. The Juvenile Justice Care and Protection Act of 2000, which had worked very well for 15 years, was amended only so that children above the age of 16 who committed heinous crimes could be tried as adult offenders in adult courts. And all of this is being done on our shoulders, the shoulders of women. This is to prevent crimes against you, they're telling us. We don't want to prosecute innocent children. We don't even want to prosecute children in conflict of law in adult courts. There was a system in place which took care of them. But today, using the bogey of crimes against women, this government has introduced two truly draconian laws against young people. And there is very little protest against it. So I know there are other speakers, but I will conclude by saying that in a country as vast as ours, in a country where on a daily basis civil liberties are being violated, I don't think it's fair to give the judiciary the status we give it. I think it's important for us to question the judiciary. I think it's important for us to question what the Supreme Court, the High Court, and all other courts in this country do. We don't do it often enough for fear that there is a contempt law. So some of us will also be thrown into jail, so what? Anyway, half the population that we know are in jail. But not questioning the judiciary, I think, is a terrible, terrible mistake we are making. Because you have no idea what is happening inside the judicial system. You have no idea how easily the judicial system gets compromised. You have no idea how the judiciary makes deals with the government of the day. And therefore, it's extremely important that we take this halo away from the judiciary and say, "Wahan pe to nyay milega," kyunki wahan pe sabse pehle nyay nahi milta. Let us take it the judiciary does not give us justice, and let us move from there. It's in the rare case that you get justice. Now, I know Justice Shakhtar passed that brilliant order in Priya Pillai's case, but I also know that it's awaiting an appeal in the Supreme Court, and I am very, very nervous about what is going to happen in the Supreme Court. So it's important for us to recognize this in our way forward, because the answer sometimes is not judicial intervention. The answers are other forms of civil liberty protests. And therefore, we need to be vigilant. We need to understand that in a country as complex as ours, where there are so many battles being fought across this country, it becomes very, very easy for a man in uniform to pick up a target and kill him while he's having lunch at Sagar Ratna and not have anyone question that. It's time that stopped. And I can tell you, it will not stop with the intervention of this government. It will only increase. It is for us to ensure that that does not happen again and again. It is for us to ensure that the Hashimpuras of the world, those tragedies, the 20 men killed in Andhra Pradesh, the 5 men killed in Telengana, that there is some resolution, that there is some accountability for these heinous crimes. Thank you.